Getting a divorce in Washington, D.C. is actually simpler than you might think. One of the spouses must be a resident of Washington, D.C. for at least 6 months before filing for divorce. Military personnel are considered residents if they have been stationed in Washington, D.C. for at least 6 months. Once residency requirements have been established, a legal grounds for a divorce must then be established. Both fault and no-fault divorce are acceptable grounds for divorce in the District of Columbia. For no-fault divorce, the reasons include mutual voluntary separation without cohabitation for 6 months, living separate and apart without cohabitation for 1 year. Living separate and apart may be accomplished under the same roof if the spouses do not share bed or food. For fault divorce, the reasons include mutual voluntary separation without cohabitation for 6 months and living separate and apart without cohabitation for 1 year. All divorces in Washington, D.C. must be filed in the Family Division of the Superior Court in the District of Columbia. Washington, D.C. does not require a parenting plan for child custody, though the court may order the parents to submit a written plan. Joint or sole custody is awarded based on the best interest of the child. The spouse's sex or sexual orientation, race, color, national origin, or political affiliation are not considered when determining custody. The factors to be considered are the age of the child's preference, the needs of the child, the wishes of the parents, the child's adjustment to his or her home, community, and school, the mental and physical health of all individuals involved, the relation of the child with parents, siblings, and other significant family members, the willingness of parents to share custody, the prior involvement of the parent in the child's life, the geographical proximity of parents, the sincerity of the parent's request, the age and number of children, the demands of parental employment, the impact of welfare benefits, any evidence of spousal or child abuse, the capacity of parents to communicate and reach shared decisions regarding the child's welfare, the potential disruption of the child's social and school life, the parent's ability to financially support a joint custody arrangement, and the benefit to the parents. Child support laws in the District of Columbia state that no preference is to be given to either parent. Either parent may be ordered to pay reasonable child support during and after a divorce proceeding. Variations from the official child support guidelines are allowed based on the following factors. The child's needs are exceptional. The non-custodial parent's income is substantially less than the custodial parent's income. A property settlement between the parents provides resources for the child above the minimum support requirements. The non-custodial parent provides support for other dependents, and the guideline amounts would cause hardship. The non-custodial parent needs a temporary reduction of no longer than 12 months in support payments to repay a substantial debt. The custodial parent provides medical insurance coverage. The custodial parent received child support payments for other children, and the custodial parent's household income is substantially greater than that of the non-custodial parent. And any other extraordinary factors. Note that child support may not be ordered to be paid through the clerk of the Superior Court. Washington, D.C. is an equitable distribution jurisdiction in determining property distribution. If there is no valid property distribution agreement, each spouse retains his or her separate property. This includes property that was acquired before marriage or acquired during marriage by gift or an inheritance. It also includes any increase in such separate property and any property acquired in exchange for such separate property. All other property, regardless of how title is held, shall be divided equitably and reasonably based on the following factors. The contribution of each spouse to the acquisition of the marital property, including the contribution of each spouse as homemaker, the length of the marriage, the occupation of the spouses, the vocational skills of the spouses, the employability of the spouse, the estate, liabilities, and needs of each spouse, and the opportunity of each for further acquisition of capital assets and income, the assets and debts of the spouses, and prior marriage of each spouse, whether the property award is instead of or in addition to alimony, any custodial provisions for the children, the age and health of the spouses, the amount and sources of income of the spouses. The conduct of the spouses during the marriage is not a factor for consideration. Alimony and spousal support divorce law in Washington, D.C. states that either spouse may be awarded alimony during or after divorce proceedings if it is proper. Specific factors listed in the statute are ability of the party seeking alimony to wholly or partly self-support, time necessary for the party seeking alimony to gain sufficient education or training, standard of living that the parties established during the marriage, duration of the marriage, circumstances contributing to the estrangement of the parties, age of each party, physical and mental condition of each party, ability of the party from whom alimony is sought to meet his or her needs while meeting the needs of the other party, the financial needs and financial resources of each party. Washington, D.C. divorce law states the court may order either or both spouses to attend parenting classes in those cases in which child custody is an issue. Visit us today at www.mydivorcepapers.com and click on District of Columbia at the bottom of the page. Let mydivorcepapers.com help you file for divorce today.